Many of you, including my friend Salvatore, have asked us to talk more about the Turin ruling. This order is crucial because it opens the way to a specific decision by the Constitutional Court on Law 74 of 2025. The court is expected to rule at the beginning of 2026, and everyone is waiting to know what will happen. The judge suspended the citizenship case and referred it to the Constitutional Court. He essentially said, before deciding on the individual claim, we need to understand whether the new law is compatible with the Constitution. The judge considered the question non-manifestly unfounded, which means the doubts are serious and legally solid. The reform could violate equality under the Article number 3, deprive people of citizenship status under Article 22, restrict the right of defense under the Article 24, and misuse the emergency decree tool under the Article 77. The question is also relevant because without the court's decision, the case cannot be resolved. The outcome will determine whether the applicant is recognized as an Italian citizen or not. Many people think the most critical part of the reform is the generational cap, limiting transmission of citizenship only to the parent and grandparents. But there is another issue that is even more difficult, at least for our Italian lawyer. Today, it is up to us to prove the non-continuity and non-interruption of citizenship, a burden of proof that is almost impossible. It's no longer enough to show that an ancestor was born in Italy. One must prove that he or she never lost Italian citizenship with documents that are often very hard to find. Here is where the reform really becomes almost impossible for many applicants. Some argue that after the decision 142, which established the non-retroactivity of the reform, the court will certainly declare it unconstitutional. Others instead read the decision differently. Parliament is free to introduce new limits, and therefore the court may reject the challenge. And this is exactly the turning point. Will the court defend rights already born, or will it confirm Parliament's power to limit them? In my personal view, both arguments are true. Parliament does have the power to set new limits, but only if they are compatible with the Constitution. And it's equally true that these new limits cannot be applied retroactively to those who were already born. So my prediction, and we will see if it proves correct, is that the reform will not apply to anyone born before its entry into force. We will soon see who is right. What is certain is that the Constitutional Court is an independent body that has always worked with the utmost seriousness. It deserves our respect and our trust, whatever its decision may be. The Constitutional Court's decision will affect thousands of families worldwide. This is why following this case is essential. If you too are waiting to understand how this decision will affect your citizenship case, remember that every situation is unique. Even one detail can change everything. Contact Mangata Avvocati for a personalized consultation. You will find the link here in the description, and please don't forget to subscribe to the channel. We will update you in the real time as soon as the court issue is ruling.